Hi, in this immigration update, I'm going to look at a new case called Basadi. This case came out on the 28th of January 2015. It's called Basadi brackets paragraph 276 ADE suitability ties, and it's 2015 UKUT 42. Now in this case, the upper tribunal considered Rule 276 ADE Roman 6, and that was the version enforced between the 9th of July 2012 and the 27th of July 2014. And the rule during that period asked the question whether an applicant would have ties, whether social, familial or cultural, to the country they'd have to go. Now, as you know, from the 27th of July, the rule was changed. Well, 28th of July, the new rule came into force, and it now says very significant obstacles. Interestingly, a judge said to me recently that he thought under very significant obstacles he could now consider everything, making the rule a complete code, but I'll leave that for another time. This case involved a deportation of somebody from DRC, and the First Tier Tribunal allowed the appeal under Article 3, Article 8 and 276 ADE. Now, firstly, the Upper Tribunal look at the treatment of Article 3. And they say the treatment of Article 3 is flawed and needs to be set aside. And they say, that, well, they refer to the judgment of the High Court in PDRC. Now, they refer to the judgment of Mr. Justice Phillips in PDRC, which found in that case that somebody with a criminal record would be at risk on return to DRC because of that criminal record. Now, what was said by the High Court in PDRC is they didn't mean to bind the tribunal, and there would need to be future country guidance. And what the Upper Tribunal said in Basadi was, in this case, the First Tier hadn't properly considered why P should be followed in that case, and there would be a risk. So they set aside the Article 3 findings. This case is, however, reported because of what was said about 276 ADE. The first thing you'll note is I said it was a deportation case. What the First Tier Tribunal had not done was consider the suitability requirements, because the suitability requirements apply to 276 ADE. So that's the first thing the Tribunal say upon reporting this, is suitability applies. They then go and consider the rule no ties, and they say it must be a rounded assessment. They consider the case law we've had so far. There's two cases. The first one was the Upper Tribunal decision in Ogundimu, then the recent Court of Appeal case in YM Uganda. So if you want to trace through the jurisprudence in relation to no ties, look at those cases. But what they say is, well, the tribunal in this case was wrong just to rely on the applicant or the appellant and his mother saying they had no ties when they knew there were some uncles there. But what has to be done is that there has to be a subjective assessment and an objective assessment. And Dr. Story relies on a case from the European Court of Human Rights called Balogun versus the UK. It's 2012 ECHR 614. And have a look at paragraph 51 of that judgment. Because in that case, even though there were ties back home that they'd remained dormant, what they said is we must consider, could dormant ties be revived? So, when assessing if somebody has ties to the country they have to go, we look at the subjective evidence, but we also consider objectively, could dormant ties be revived if somebody returned? So this case is interesting. Now, the rule, it's going to have limited utility because the rule is gone, but we're going to have some cases still going through the system to which this rule applied and now being probably considered by the Upper Tribunal. So have a look at Basadi. Interesting for what it says about Article 3 and PDRC. Remember, suitability applies, but also when applying the no ties, remember the subjective and the objective.